this on the 28th. But before I go into what has happened today and other matters, I want to record our disappointment with respect to the language used this morning by a senior member of the bar and former president of the Greater Accra Regional Bar, Mr. Frank Davis. The language that he employed this morning is unacceptable in describing the actions of petitioners' lawyers as theatricals, in describing us as persons who intend to be intransigent and disobedient to the orders of the court. I am sure that Frank Davis knows, Mr. Frank Davis knows, that all the applications that we have brought are within the framework of the law. You are journalists. Please do a bit of research. Read CI 99. And please tell us where in CI 99 it is said that you cannot bring an application for stay of proceedings. Tell us where in CI 99 it is said that you cannot bring an application for interrogatories. And tell us where in CI 99 it is stated that as a petitioner, you cannot bring any interlocutory application before the court. These are all mechanisms that legal practitioners employ. And we have employed them in a way that is not abusive of our rights within the framework of the Supreme Court rules. And so for him to employ that language is most unacceptable, and we take exception to what he said this morning. Ladies and gentlemen, there is a fetish that is being made of 42 days stipulated by law for this trial. Again, I want to refer you to CI 99, which is the amendment to the Supreme Court Rules, CI 16. Go and look at Schedule 2 to CI 99. The schedule is very clear that the trial is supposed to take place from January to March. Now just do a bit of computation. January has 31 days. If February is not in a leap year, it has 28 days. And then March has 31 days. That's 90 days for you. Was the lawmaker wrong in stipulating this period for a trial? The view we have taken of this matter is simple. That the trial is supposed, the 42 days is the number of days, working days, that the court is supposed to use in discharging the petition. It is not to be computed on a day-by-day basis. I also wish to make it abundantly clear that this is far from being a frivolous and vexatious petition that His Excellency John Dramani Mahama has filed. The impression being created by the MPP, the ruling MPP, is that we came to court with a frivolous and empty petition, and we are just seeking to engage in theatricals so that the petition will not be heard. His Excellency John Dramani Mahama is far from being such a person. If you look at the petition, it has two purposes. The first one is to hold the chairperson of the Electoral Commission, Jane Adukwe Mensah, accountable for a violation of the Constitution. Now, you have practiced journalism in this country for a period sufficient enough to know that we have never had a situation where the chairperson makes a declaration based upon one figure, issues an instrument validating the declaration based upon the figure that she has used in making the declaration, and then subsequently revises that figure. Repeatedly revising the figure. Now that is unconstitutional conduct, and we want her to be held accountable for that. We are saying that that conduct that she engaged in is unconstitutional. It's not supported by any provision of the Constitution. And again, as journalists, you should be asking her, when she did the revision, were there agents of the political parties there? That is a critical question that you should be asking her. The second purpose of the petition is with respect to the mathematics of Article 63, Clause 4 of the Constitution. It requires that for a person to be validly declared president of this republic, the person must have obtained more than 50% of the votes. Our petition is very clear that His Excellency Nana Addo Dankwa Akufo-Addo, when he was declared president-elect by the chairperson of the Electoral Commission, had not obtained more than 50% of the vote. That is the mathematics of Article 69. And if this is not an important issue, I don't know what it is. And therefore, as journalists, when we file our witness statement, read it carefully, and you will see that this is not an empty petition. They are preempting Ghanaians to think that we are joking in court, but we are not joking in court.
At the start of the proceedings, you realized that your colleague Sanita was explaining to the court why you didn't file the witness statement. If you could clarify that, please.
Yes. Filed a petition for stay of proceedings. Now, for the layman, that is an application which is brought before the court to stay its hand with respect to everything in relation to the proceedings. Everything in relation to the proceedings, pending the determination of a matter that an applicant has put before the court. And you will recall that we have an application for review to disallow our administration of the secretaries. And that application was fixed by the court itself for hearing on the 28th of January. And therefore, we thought that given the impact of the interrogatories on our witness statement, because if Jane Mensah answers all the questions, they will bear on the nature, content, and scope of our witness statement. And therefore, we said, let us abide the decision of the court with respect to the witness, the review application, and after that, we will incorporate the answers into our witness statement. That is what that is why we brought the application for stay. Now, as Mr. Chikata pointed out in court, there was no intention whatsoever on our part to disobey the court. I am sure in all his life as a legal practitioner, Mr. Chikata has never disobeyed any court order. And this is not going to be the first time that he has done that. And I'm sure Frank Davids and his colleagues know very well that applying for stay of proceedings means that if you take any fresh step yourself, you are undermining your own application. And I'm sure if we had been given the opportunity to move our application for stay, and if we had filed any fresh process pursuant to the orders of the court, the same people would have raised objections, saying that we have taken fresh steps, we have waived our right to have the proceedings stayed. So, yes, they were involved in double speak this morning. Yes.
That you wanted some additional information to be added to the review that you were asking for. Is that not a contradiction to the fact that you had filed for a stay? No. We didn't file another for additional information. Okay? Neither did we file to amend our application for review. What we did to add an additional legal ground. That is different.
To the yet to be heard.
To the yet to be heard review application. Okay? So, cut for stay of proceedings. I don't think so.
The second respondent argues that having filed their response to your statement of claim, you have used the backdoor to file for amendment.
Well, I don't know how we came back door. We have preliminary applications pending, and we want those preliminary applications determined before we file our witness statement. We wait for them to file so that we can then
come through the back door. We knew our case beforehand. We thought carefully about our case before coming to court. We are not relying on them in order to win this case. Yes. Now, one at a time.
You were given 24 hours, the last hearing, all your witnesses. During that particular hearing, your counsel, the time given. Today, you've been given the same duration and close of working days tomorrow.
No.
You had consent with the same duration.
Well, you see, the initial consent related to the for case management. The fact that we came for case management and we were not given an opportunity to determine, for instance, how many witnesses we were going to call, how many documents, and the nature of the documents we were going to tender, and so on and so forth. That is what case management is about. And that is what determines the period of the trial. Okay, so if, for instance, we came for case management, and we were not given an opportunity to determine, for instance, how many witnesses we were going to call, how many documents, and the nature of the documents we were going to tender, and so on and so forth. That is what case management is about. And that is what determines the period of the trial. Okay, so if, for instance, we are calling only one witness, the court may decide that that witness should be cross-examined just for 2 days by each of the respondents. Okay, if we are calling 5 witnesses, then we are looking at a 10-day period of cross-examination. So that is why we thought that the compression of the time for case management was not, proper. And then also the fact that we're giving just 1 day in order to file a witness statement. Okay, but we are prepared, and the witness statement will be filed with all its exhibits, by close of day tomorrow.
The court made reference to
Sorry.
CI 16.
That is so.
Making the point that should this under a case with you reserve the right to dismiss the petition trial. What's your assessment?
Well, I mean, we are fully aware of the consequences of Rule 79 of the Supreme Court rules. It's a rule that cuts across from district court all the way to the Supreme Court. And as well as we are very much aware that if you fail to take a step ordered by the court is within its discretion and power to dismiss your application or the case that you have brought. And so we are very much aware of it, but we don't intend to bring about a situation that will trigger the application of Rule 79. The witness statement will be filed tomorrow, and I'm very sure that being a public document, the press will have copies of that witness statement.
Also, there were a rule in the Supreme Court and the court that standalone commercial court indicating that staff application does not necessarily mean that the proceedings case should be adjourned after should be put on hold. What is your response to that?
Well, I like the fact that you are attempting to be a lawyer, but that came out very clearly in the last hearing. You remember one of the justices asked Mr. Sikata whether by filing his application for review, that is an automatic stay of proceedings. Okay. Now we need. That means that was a hint that we needed to bring a formal application if we wanted stay of proceedings, and that is exactly what we have done. Okay. We didn't depart from the established rules, practices, and conventions of the superior courts. Thank you very much.
Yasam wakwa babiem ediaba Adom TV so the esi wo court the a lawyer for ni nkyere mu omo nsemisa for nsemisa anase sentrefo nsemisa ho no yie no omo de aba no sabre petrosol petrol papa wo dwaso DBS roofing enchansi papa obinya de aboard dan so na fe kwa Mr. onomo a otiapo enanwumre today in court beba na fe yedwedwamu edi akero lawyer nana AJ Bafo nana yenwie na yemfansi ene de akosie ni. Hello, lawyer. Nana AJ Bafo NTN Kama Mfana Siema Dominic Kisieboa Maule Presla a won mu aboya chidom obehwe camera sound light ubia so aye na fam de midin edna na sei ampofo ejei na executive producer AC ohene ye hwese ye bepa de kakraka bi dia ma ye akra na eja akra atafre ho a edimosi nyame admo china ye be se hia